Hi and a very good morning to madam. We are from Tutorial 10, Group B. My name is Maithili Anna from Bajira, together with my teammate Itrasi Angeline, Pragat Singh Toor, and Muhammad Akif Zikri. Today we are delving into a fascinating yet complex case involving discharge of breach, discharge of performance, and discharge of frustration. The central question we aim to explore is whether the contract between the parties can be discharged and the legal compensation can be made. For the first question, the case presents a web of relationship and agreement. Pak Long agreed to supply 10,000 kg to Nagapuri in three installments, where the first installment, 3,000 kg, was able to be delivered on time. But, however, due to unforeseen circumstances of heavy rain during the second installment, only 2,000 out of 4,000 kg was able to deliver, while the other half turned to do severe durian fruit rot. Subsequently, Park Long has informed Nagapuri regarding the issue, causing Nagapuri to reject the delivery, terminate the contract, and refuse to pay. Due to this, Park Long now claims payment and damages. Furthermore, for the second question, this case demonstrates on how Beacon Sunjambat was contracted by the government to build a bridge across Sungai Muar for 100 million ringgit, where the contract was signed on the 15th February 2024 and was to be completed by 31st January 2026. The payment was made in installment based on the progress, and the contract included a force majeure clause. However, in March 2025, severe flood caused damages to the site and shifted the riverbed, causing Beacon to claim frustration. The government then went on to argue that it was only temporary disruption, therefore, the force majeure clause applies. Each of my group member will bring their own unique perspective and analysis to shed light on this intricate legal dilemma. By the end of our presentation, we hope to provide clarity regarding the discharge of contract and to propose a potential resolution for the parties involved in this case. With this, let us proceed to Pragat, who will address the first issue. Thank you.
Thank you, Maithili. Good morning, everyone. My name is Pragat Singh Toor, and I'll be explaining the first issue in this question. The first issue here is whether Nagapuri was entitled to terminate the contract due to the short delivery of the second installment. Now, on to the relevant authorities. Section 40 of the Contracts Act 1950 states that when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct his equines in its continuance. In the case of Berjaya Times Square and M. Concepcion Barat 2010, the court laid down the situation for a breach of contract, namely, the defaulting party refuses to perform the contract or the defaulting party disabled himself from performing the contract. The contract does not come to an end, but the breach gives the innocent party an option to rescind, terminate, or continue the contract. In the case of Maple Flock Co. Limited and Universal Furniture Products Wembley Limited, a contract was entered into for the supply of 100 tons flock of government standard to be delivered by installments. However, after 18 deliveries has been made, it was found that the 16th delivery was defective. Universal Furniture then accepted two further deliveries, but then purported to terminate the contracts based on the single defective installment. The court held that a single defective installment did not entitle the buyer to terminate the whole contract unless the breach was repudiatory or indicative of future breaches. Furthermore, Section 57, subsection 2 of the Contracts Act 1950 states that a contract to do an act which, after the contract is made, becomes impossible or by reason of some event by the promiser could not present, unlawful becomes void when the act becomes impossible or unlawful. The impossibility to perform the contract here must be absolute and not partial or temporary. However, in the case of Pacific Forest Industries Sdn Berhad and another against Lim Wen Chin and another, the court held that a contract is not frustrated just because it is difficult to perform or interpret or because of financial difficulty. Frustration only applies when the contract is made and the change in circumstances makes the performance legally or physically impossible to perform. As mentioned in Pacific Forest Industries Sdn Berhad and another against Lim Wen Chi and another, the contract is not frustrated here merely because of the defect in the second installment by Pak Long. Frustration only applies when a change in circumstances make performance legally or physically impossible to perform. Since Pak Long had performed the first installment fully and had shown intent and good faith in delivering part of the second installment, and he also indicated not indicated an inability to perform the third installment, the contract is not frustrated here. Hence, in conclusion, Nagapuri is not entitled to terminate the contract with Pak Long merely because of the short delivery of the second installment, as the delivery as Pak Long has not breached its contract with Nagapuri. That's all from me. Thank you, madam. Now I'll pass the floor to Akif.
Thank you, Pragat. Today I will be discussing whether Pak Long is entitled to payment and damages for the 2,000 kilogram delivered. We'll be looking at the legal doctrine of quantum merit, key contract law principle, relevant provisions under the Contract Act 1950, and also the supporting case law. Now I will be explaining the relevant authorities for this issue. Under general contract law, a party is not entitled to payment until they have finished all of the action described in the contract. In Carter against Forward, the general rule that performance must be complete and exact before a party is paid is very well illustrated. In this case, the defendant agreed to pay Carter 30 guineas, provided that he proceeded, continued, and performed his duty as second mate and vessel sailing from Jamaica to Liverpool. The voyage began on 2 August and Carter died on 20 September when the ship was 20 days short of Liverpool. Carter's wisdom claimed for a proportion of Carter's agreed wages, and the claim failed on the ground that under terms of the contract, Carter was obligated to perform the agreed duties before he would be paid. It meant that a party who hasn't met all the obligations in their contract cannot expect any payment from the job that has been done. Doing so guarantees that both parties stick to exactly what was agreed upon, which is vital in business transactions because result and predictability matter the most. There are situations where the rule can be broken. A party may still be eligible for compensation from courts even if not every condition has been fulfilled. This is when the principle of quantum merit can be used. Where the other party has accepted partial performance, performed any alleviating acts, or benefited in any way from the work provided, a party can ask for compensation. The term quantum merit rested in implied contract. It is said that there must be an implicit promise by the defendant to pay for the part performance. Further, the defendant must have a choice whether to accept or reject the work done. It may also be possible to infer from the circumstances a fresh agreement by the parties that payment shall be made on the work that already done. On the other hand, the implied contract basis of awarding quantum merit claim was applied in the case of Haji Hasnan against Tan Akian. In this case, the appellant, having obtained a contract to construct roads, subcontracted with the respondent for his performance, the appellant inspected the work and found that it was not properly done. The appellant terminated the contract before the work was completed without giving notice to the respondent. He immediately entered into a fresh contract with another person for the completion of the work. The respondent requested an extension of time to complete, and when it was not granted, brought an action for the work and material supplied. The Court of Appeal held that the appellant was in breach of contract and the respondent was entitled to recover on the basis of quantum merit. From the circumstances, the Court of Appeal held that there was an implied contract on the part of the appellant to pay for the work and labor done and material supplied. This matter falls under the provision of the Contract Act 1950 that makes it easier to use quantum merit in cases like this. Section 65 sub B says that if a contract is broken before being fulfilled, the person who has performed part of it can be rewarded for what they have already done or received. This follows the idea that when a contract terminates, money should still go to the party for services they delivered in good trust. The plaintiff in Yi Ho Lung Corp's Neighborhood against Kwong Fook Sang Co. supplied goods, but they made the contract under which they were supplied void. In spite of this, the defendant had accepted the gift and used them. It was decided in court that the plaintiff would be awarded the amount the goods were worth. Under Section 71 of the Contract Act 1950, it says that if someone does something legal for another or delivers something by accident without expecting anything in return, and the other party takes advantage, the first person is obligated to be compensated. The court held in Yi Hong Lung that damages should be awarded since the goods were used by the defendant and there was no proof that the plaintiff expected them to be supplied free of charge. This situation reiterates that justice requires someone who obtains a non-gracious benefit not to be unjustly enriched with someone else's money. In addition, the Act in Section 66 explains that any person given an advantage through a void agreement must pay back the benefit or make up for it. Because of this, restitution is used when a contract cannot be formed. Yet, the person who keeps a benefit is still expected to return it. This means that the court may still give compensation if the contract has not been fully carried out, especially in the receiving party voluntarily accepted, used, and benefited from the performance. Law is set to stop any advantage being taken and provides that no one may non-gratuitous effort for a contract where performances is only partial and still retained by the other party. Now, I will be applying these relevant authorities to the Pak Long situation. Based on the facts, we know that Pak Long did not completely fulfill the contract because he delivered only 2,000 kilograms, whereas the second installment was supposed to be 4,000 kilograms. Because of heavy rain and damaged fruit, the shortfall was 50% less than was expected. Being informed, Nagapuri's legal team refused to accept the goods and ended the contract without consent from the other party. If a party does not fulfill the obligation, the law stated in Carter against Powell keeps them from getting payment. If suppliers cannot deliver at the agreed rate by 50%, the buyer may consider the incident substantial enough to cancel. As we saw in issue 1, since the breach did not affect the main condition of the agreement, Nagapuri could not terminate the contract as the contract was not structured as one whole obligation. Because Nagapuri had the contract in place and could not legally terminate it until after the delivery, Pak Long is allowed compensation for the 2,000 kilogram delivered using quantum merit. To sustain his claim, Pak Long must prove that Nagapuri got involved with the durians, accepting or benefiting from them. According to Section 71 of the Contract Act 1950, if a person delivers an item to someone they expect to be paid for, the recipient should compensate them if they get any benefits from it. If Nagapuri takes up the durian, such as through resale or personal consumption, Pak Long is entitled to payment, like in the case of Haji Hassan and Tad Hakian, and Ye Hong Long Corps Sdn Bhd against Hong Fook Sang Co. Courts ruled that plaintiffs are paid quantum merit when their partial works benefit their defendants. In conclusion, Pak Long should receive payment for the durian he delivered, and he can also seek compensation for the damages from the partial performance. Due to him missing part of his contractual duties, he is able to ask for reasonable payment for the service he provided. When a non-gratuitous benefit is provided, the giver is entitled to a reasonable payment under Contract Act 1950, Section 65, 66, and also 71. As the cases Haji Hassan against Tad Hakian and Ye Hong Long Corps Sdn Bhd against Hong Fook Sang Co. demonstrate so. Pak Long can get the remaining payment for the durians delivered and seek damages for what was not fully served. Thank you. Now on to Angeline.
Thank you, Akif. Hello, everyone. My name is Nithya Sri Angeline, and today I'll be explaining the first issue based on the second question. Now, firstly, the issue here is whether the contract between Beacon and the government to construct a bridge was frustrated by the unprecedented flooding, thereby releasing Beacon from its contractual obligations. Now, the relevant law here is Section 57, subsection 2 of the Contracts Act 1950, which states that a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promiser could not prevent, becomes unlawful, becomes void when the act becomes impossible or unlawful. Now, although the Act here does not use the term frustration, this provision is accepted as incorporating the doctrine of frustration, which terminates a contract automatically when performance becomes impossible or radically different due to a supervening event. Now, the test of frustration is laid down in the case of Davies Contractors Limited and Faham UDC in 1956, where Lord Radcliffe stated here that frustration occurs whenever the law recognizes that without default or either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. Now, in the case of Davies here, the appellants agreed to build for the respondents 78 houses within 8 months. But due to a lack of skilled labor and various other reasons, the work took 22 months. Now, the appellants here contended that the contract had been entered into the note that supplies of labor and material would be available to complete the work within 8 months. However, this was not the case here. The resulting delay, they argued, amounted to frustration of the contract. Now, the court here held that the contract had not been frustrated. The fact that there had been an unexpected turn of events which rendered the contract more onerous than had been contemplated was not a ground for relieving the contractors of the obligations which initially they had undertaken. Now, the test in Davies Contractors was explained by Lord Denning in the case of Eugenia, and it states that to see if the doctrine applies, you must first construe the contract and determine whether the parties themselves have made provision for the situation that has arisen. Now, if they have, there is no frustration and the contract must govern. The parties are bound by what they have agreed on, but if they have not provided for it, then we must compare the new situation with that which was contemplated at the time of contract formation. We must ask, how different is it? Is it not enough that the performance has merely become burdensome or more expensive for one of the parties? That alone does not amount to frustration. It must be positively unjust to hold the parties to their original bargain in the light of the radically changed circumstances. However, in the case of the Eugenia, the Court of Appeal here held that the doctrine of frustration did not apply because it was self-induced. Further, it did not pass the test in Davies Contractors, and the event had caused the performance of the contracts a thing radically different from that which was undertaken by the contract. In Malaysia, the House of Lords' decision in Davies Contractors was applied by the Federal Court in the case of Ramli bin Zakaria and others in Government of Malaysia in 1982. Now, in this case, the appellants were a group of 86 vocational school teachers who were successful in their application for teachers training. Now, one of the conditions of the offer which they accepted was that the teachers would be accepted as teachers on the UTS scale when they complete the course. However, by the time they completed the course of training, the UTS scale had been abolished and the Abdul Aziz scheme came into force. Now, the appellants here were offered salaries under the Abdul Aziz scheme. The appellants here claimed that they should have been paid salaries and allowances under the UTS scheme. Now the respondents pleaded that as the recruitment of teachers into the UTS scheme had been discontinued, the offer to employ them under the UTS scheme had become frustrated. The Federal Court held that the service agreement which contained the provisions of a particular salary scheme was not frustrated when the new salary scheme was implemented to replace the old scheme. Now, the Federal Court said that it is wrong to say that the contract was not capable of being performed. Abdul Hamid, Federal Court judge, stated here that in short, it would appear that after a contract has been entered into, there is a change of circumstances, but the changed circumstances does not render a fundamental or radical change in the obligation originally undertaken to make the performance of the contract something radically different from that originally undertaken. Now, the contract does not become impossible and it is not discharged by frustration. In the case of Lai Kok Kit at Sulaiman Lai bin Abdullah, MBM Finance Berhad in 2000, the Court of Appeal referred to Section 57, Subsection 2 of the Contracts Act and Ramli Zakaria's case and accepted this test stated by Federal Court Judge Abdul Hamid therein to be an accurate proposition governing the law of frustration. Lastly, if the contract is said to be frustrated, Section 2J of the Contracts Act 1950 applies here, where a contract that ceases to be enforceable by law becomes void. Moving on. Applying the law to the facts of the case, Bin Khan Sendirian Berhad argues here that the contract to construct a bridge was frustrated due to a unprecedented and prolonged flooding. So now, under Section 57, Subsection 2 of the Contracts Act 1950, a contract becomes void when a supervening event renders the performance impossible or the obligation fundamentally different from what was originally agreed on. Now, to determine whether frustration applies, first we must assess whether the flooding caused a radical change in the nature of the contractual obligations. The facts show that the flooding not only caused physical damage to the partially completed bridge and surrounding areas, but it also severely disrupted access to the construction site. More significantly, the flood caused the riverbed to shift, requiring a substantial redesign and reinforcement of the bridge. Now, this goes beyond mere inconvenience or delay. It transforms the nature of the performance required under the contract. According to the principle established in Ramli bin Zakaria and others and Government of Malaysia in 1982, where the court adopted the English position in Davies Contractors' case, the frustration must involve a fundamental change to the obligation. Therefore, The unprecedented flooding and its consequences likely amount to a frustrating event under the Malaysian contract law, thereby discharging Beacon from further performance. In conclusion, applying the principles under Section 57, subsection 2 of the Contracts Act 1950, as well as the radical change test in Davis contractors, it is likely that the contract between Beacon and the government has been frustrated. Now, the extensive flooding, destruction, and the need for a complete redesign represent a fundamental alteration of Beacon's obligations. Now, this goes beyond delay or cost escalation and alters the essence of the original agreement. Therefore, the contract should be regarded as void under Section 57, subsection 2, and Beacon is discharged from further performance. Thank you, and I now pass the time to Maithili.
Thank you, Angelique. Now I'll be discussing whether the existence of a force majeure clause prevents the doctrine of frustration from applying in this scenario. The relevant authorities that will be discussed for a force majeure clause. A force majeure clause in a contract is a risk allocation provision that specifies certain events such as natural disaster, wars, pandemic, which if they occur may excuse one or both parties from performing the contractual obligation without liabilities. The doctrine usually provides for a temporary suspension of obligation. In Malaysia contract law, the doctrine of frustration under Section 57, sub 2 of the Contract Act 1950 applies only where there's no provision has been made in the contract for the event that has occurred. If the parties has already addressed the supervening event in a force majeure clause, the express term of the contract will prevail. Next, we will discuss the case of Intan Payong Sdn Bhd against Goh Saw Chan Sdn Bhd, where the developer had claimed that the delay in delivering vacant possession was due to the local authority delay in issuing certificate of fitness of occupation, which is the CFO, which was beyond their control. They relied here on the force majeure clause, which is clause 24, that includes the failure to obtain the necessary approval. The courts, however, reject the developer's force majeure defense, holding that the burden of proof was not on the developer to show the delay was truly beyond their control. Also, the developer failed to show reasonable effort were made to obtain the CFO, and the clause did not protect the developer due to the insufficient evidence for a force of majeure. Furthermore, within the Intan Payong case, the High Court emphasized that a party relying on the force majeure clause must not only prove the occurrence of an event listed in the clause, for example, natural disaster, but also the event has to be hindered, delayed, or prevented the performance, which caused the non-performance to be beyond the party's control, and that the party took reasonable steps to mitigate the impact of the event. Moving on, let's look into Section 15 of the Civil Law Act 1956, where Section 15 sub 1 of the Civil Law Act states that when a contract has become impossible of performance or has been otherwise frustrated and the parties are discharged from the further or performance of the contract. Whereas Section 57 sub 2 of the Contract Act 1950s does not define what constitutes impossibility or when a change is so fundamental that it qualifies as frustration. This is where Section 15 becomes relevant, allowing the court to draw from English cases such as the case of Davy Contractors against Varham, where frustration occurred when an event changed the obligation into something radically different and not just more expensive or difficult. Also, in the case of the Eugenia, where the frustration cannot be applied if the event was possible or self-induced, and in the case of Taylor against Cadwell, where it stated that frustration arises if the contract becomes impossible to perform due to the destruction of the subject matter. Now, I will be applying the relevant authorities into the facts of the case. Based on the fact, Beacon seeks to rely on the force majeure clause following the unprecedented flooding that caused significant damages to the partially complete bridge and disrupt access to the construction site. This clause is in the contract includes natural disaster as a force majeure event, which will similarly cover the flood. However, as established in Intan Payong Sdn Bhd against Goh Saw Chan Sdn Bhd, it is not enough to simply refer to the force majeure clause, as the party relying on it must prove the High Court condition. In the B Constitution, while the flooding falls within the natural disaster category, the burden remains on Beacon to demonstrate that they did everything reasonably possible to minimize the impact. These include showing that the disruption to the access, the damages to the structure, and the consequences of the riverbed shift were not only beyond their control, but could not have been reasonably managed or anticipated. However, the facts state that Beacon claimed the contract was frustrated and sought to be released from the obligation. The government refused, arguing that the force majeure clause only covered temporary destruction, not fundamental change caused by the flood. This statement clearly mentioned that the force majeure clause does not apply. Since the clause does not cover fundamental changes in the project scope, Section 57 sub 2 remains applicable. Section 15 of Civil Law Act 1956, however, may be applicable. This section allows Malaysian courts to apply English common law where the local statutes are silent or inadequate. While Section 57 sub 2 of the Contract Act 1950 provides for frustration, it does not define the scope impossibility or radically change. Therefore, Section 15 of the English cases like Davies Contractor against Parham, the Eugenie and the Eugenia help interpret the concept. Applying this principle, the unprecedented flood and riverbed shift in the Beacon scenario arguably render the contract performance radically different. Therefore, Section 15 may be applicable. In conclusion, although the contract includes a force majeure clause, it may not cover the fundamental changes causing by the flood. Under Section 57 sub 2 of the Contract Act 1950, the contract could still be frustrated under Section 15 of the Civil Law Act, allow the court to draw from the English cases such as the case of Davies Contractor, the Eugenia, and Taylor versus Cadwell. Thank you. To summarize both situations, first looking at question 1, Park Long partial non-performance due to unforeseen natural circumstances does not constitute a fundamental breach under Malaysian contract law, as established in the Maple Flock and Berjaya Times Square case. The partial performance does not justify contract termination, especially when Park Long acted in good faith and I informed Nagapuri immediately about the situation. Therefore, Nagapuri is not entitled to terminate the contract. Furthermore, based on quantum merit principle and Section 65, 66, and 71 of the Contract Act 1950, Park Long is entitled to the payment and possible damages of 2,000 kg durian delivered provided Nagapuri benefited from them. Apart from that, to summarize question 2, Beacon situation involved a radical transformation of the contractual obligation due to prolonged flooding, which caused structural damage and required complete redesign of the bridge. Although a force majeure clause was included, it did not account for such fundamental changes. Applying Section 57 sub 2 of the Contract Act 1950 and Davies contractor test on the frustration, the contract is likely to be considered frustrated. Section 15 of the Civil Law Act 1956 supports this by allowing reference to English common law cases. Thank you, madam.